Reggie's here. He's a constitutional law professor. And he has, I just wanted to bring you on. He's also a Demcast board member and a great guy. And so I just wanted to bring him on to share his sort of legal perspective on what's happening. So take it away.
All right. So I watched most of the defense today, which wasn't very long, and most of it was useless in a lot of it was whataboutism. That video, that 11-minute video of people just saying fighting, it was absolutely useless, and it was I think it hurt them. There are two key, I think, legal issues that one that they really emphasized on that I want to talk about, which is the free speech issue, and then one that they didn't talk about, but I think it's still a live argument for the defense, which is a jurisdictional issue. And I just am writing an article about this issue, about jurisdiction, and it's important because there are senators who would otherwise convict, but for the jurisdictional argument. I think Mitch McConnell is one of them, because I think he really does want to convict, but he voted against jurisdiction at the outset, and that might be the basis for saying, okay, acquittal based on lack of jurisdiction. So we want to rebut that argument as much as we can. That, in fact, there is jurisdiction. It is constitutional. Okay, so first free speech and then jurisdiction. Let me start with the jurisdictional argument, since we've already started talking about jurisdiction. The jurisdictional argument comes down to the fact that Trump is no longer in office. Okay, and the question is, does impeachment process apply to a former president? And the central argument they make is that impeachment is about removing the president from office. Okay, and then they argue, well, he's already out of office, so what's the point? It's moot. Okay, and there is something to that point, right? In terms of, well, is logically there's a logic to it. And there were questions that came up during the question and answer session. There are several questions going to jurisdiction. Okay, so it's still a live issue, even though technically you had a majority vote saying there was jurisdiction. Okay, so by jurisdiction, the issue is whether or not you can actually have a trial in the first place, that whether it's constitutional, this process. And if some senators argue there's no jurisdiction, they may acquit on that basis, even if they think he's guilty of incitement. Okay, so it's a process argument for saying acquittal. And we want, as much as possible, force the senators to address the merits of the case, right? Don't give him an escape hatch to get out of convicting him, saying, oh no, for lack of jurisdiction, I'm going to acquit. Okay, and trying to make it so that at the end, because I think Nick is right, we're probably not going to get the 2/3 vote to convict, but afterwards, when the senators are being interviewed for why they have acquitted, we don't want them saying because of lack of jurisdiction. We want them to force them to say, well, I didn't think it was that big a deal that he incited the people to go out and storm the Capitol. Okay, so even if we lose, it's still important to deal with the jurisdictional issue. Okay, so how do we deal with that? And let me first state the language of the impeachment clause, which talks about removal and the impeachment and removal. So it states the president shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. Okay, so it talks about removal, impeachment, conviction, high crimes, and misdemeanors. And here's the key distinction. It's a distinction between removal and conviction. Okay, removal and conviction. And the people think the impeachment process is about removal. I think generally we all think that. But what I'm arguing is that it's about conviction, which is entirely different from removal. So the argument is impeachment is about acquitting or convicting the president for high crimes. It's not about removing the president. Okay, and then let me tease this out further. What does that mean? What's the difference? Think about it this way. Well, first, high crimes. A president can be impeached and removed for committing a high crime or misdemeanor. And what does that mean? We talked about this at the first impeachment trial. It meant, basically an abuse, something the president did that amounted to abuse of power. Okay, and Professor Lawrence Tribe, I'm sure you're familiar with Lawrence Tribe. He says something's an abuse of power, a high crime, if it's such an egregious act that it renders the president unfit for office, that he's not qualified anymore to hold this office. He's a threat, a clear and present danger, right, to the nation, to democracy. Okay, so when we say when I'm saying that impeachment trial is about convicting the president for a high crime, the question it's focused on is the president fit or unfit to hold office? Okay, that's the central question. Removal is something different from that. Okay, so what's the difference? It comes down to, it's actually really a simple difference. It comes down to finding guilt on one hand, and then the consequences of that finding on the other hand. It's about finding someone engaged in wrongdoing versus firing someone for that wrongdoing. Conviction is about culpability, that Trump did something wrong. He committed a high crime. Removal is about, well, what do we do about that? Well, fire him, right? Remove him from the office, okay? Right. And if you look at the impeachment clause, it's clear the president shall be removed from office on impeachment for and conviction of treason. Two separate things. Okay, and then this is the key part about this clause. It says the president shall be removed upon conviction. Okay, so what does that mean? Shall be removed? Let's think about it this way. Who does the removing under the impeachment clause? It's not the Senate. The Senate convicts. That's their role in the impeachment trial. It's not to remove. Then who does the removing? When we think about it, it's the Constitution that requires removal. The way I think about it is that under the impeachment clause, the Constitution acts like a sentencing guideline, imposing a mandatory sentence of removal once the Senate convicts the president for a high crime. Okay, so hopefully that makes sense. And what that means is if the focus of the impeachment trial is conviction for a high crime, the central inquiry is he unfit to hold office or not? Not whether he should be removed. It may seem weird, but the trial is actually not about removal at all. It's really about the question, unfit or fit to hold office. Okay, and that is the key distinction, because once you say, all right, well, if that's what it's about, it's more than just, it can be more than just about removal. And that's in fact accurate. Okay, the determination of whether someone's fit or unfit to hold office has a lot of implications beyond, well, he should be removed from office. And the fact that he is no longer in office then is irrelevant if there are these other reasons for having this trial and convicting him, i.e. jurisdiction. Okay, there's jurisdiction because the only question for the Senate is unfit or fit for trial. It's not about removal. So the fact that removal is not an option doesn't take away jurisdiction, and that's my argument. Okay. Okay. So basically, the impeachment trial is about figuring out whether or not Trump is unfit to be president. What are some of the rationales or reasons for having such a trial and having such a determination? Okay, and let me give you 3 reasons. The first one is there is still a consequence for Trump, right? If he's convicted of committing a high crime, disqualification from holding future office. So it's really it's almost a really straightforward argument. The question about fitness for office is not moot. There is still a consequence for Trump. Absolutely, that's the straightforward argument. And if you, as a talking point, you definitely want to hit on that. It is not moot. Determining fitness is still relevant to figuring out whether he should be barred from future office. Okay, so argument 1. Then two other arguments that don't require whether or not focusing on disqualification. Even if the Constitution did not allow for disqualification, these reasons, I think, justify a trial, even if removal is no longer an option, even disqualification is no longer an option. One, precedent, that it's a basis for precedent. Jamie Raskin today had a great line as to say, here's what this trial is about, not about disqualification, but it's about setting a presidential standard of conduct. Okay, I love that line, presidential standard of conduct, a standard for what presidents can or can't do. And that a conviction or acquittal on that question of fitness helps develop a standard of conduct for presidents about what is appropriate behavior, what's not appropriate. And that is very important. Okay, so a conviction or acquittal on the merits, on the question of fitness, helps create that standard of conduct. And so it's a question of, for future, it's guiding future presidents about what's appropriate, inappropriate. And it's also guidance for Congress, for the House and the Senate, in terms of, well, if the House wants, should we impeach another president? A conviction or removal, acquittal on the merits in a previous case can serve as precedent guidance. So it sets up an impeachment trial on the merits, helps create a presidential standard of conduct and guidance for Congress in the future to deal with possible impeachments. The third argument is that determination about acquittal or conviction based on the merits it's a statement about our nation and our core values and principles. Okay, a conviction regarding Trump would clarify, what do we stand for as a nation? What are our principles? Okay, what does it mean to be an American citizen, a patriot? Okay, and I want to suggest that you want to emphasize that this is a national decision. The impeachment or a conviction requires 2/3 of the Senate to convict. That's essentially requiring a consensus of this nation to say we do not approve of this behavior. Okay, so it's a national. So one thing, it's a national decision about this nation, our values and principles. Okay, if that's so, we want a decision. Do we want to acquit and say this kind of behavior is consistent with our nation, consistent with our values, right? That's the argument you want to make. And it's about reinforcing the rule of law and democracy. Okay, so hammer the point. And a talking point might be to someone who says, what's the point? Well, it's about saying, what would it say about our nation if we say Trump, we acquit Trump of organizing and inciting an insurrection against Congress? Okay, right. So you see how you could frame this issue about national values and principle. Okay, and then so that's a jurisdictional issue. Let me turn to the First Amendment issue. Okay, the issues raised. The main issue raised is the defense raised was Trump's speech is protected First Amendment speech. Okay, and they focus on his speech on January 6th. And the critique is you want to say it's not protected speech. And there are a couple arguments you can make. One is incitement. Incitement actually is not protected First Amendment speech. Right. Okay, so you can argue it's incitement, and as incitement, there is no free speech protection for incitement. Then the next question, well, did he really commit incitement? Okay, and the defense argued, Trump's defense argued, no, his conduct, his speech did not meet the elements of incitement based on a case called Brandenburg. Okay, and here's two arguments for that, against that argument. One is actually the standard was met. Okay, that in fact, based on the standard, Trump incited, just by that speech alone, Trump incited, committed incitement, and so there is no free speech protection. And the incitement test is two prongs. You have to ask whether the speech was directed to inciting or producing imminent lawless action. Okay, and the second prong is, was the speech likely to incite or produce such action? Okay, so let's start with the first one. Was the speech directed to inciting or producing imminent lawless action? You can make the argument, absolutely, right, that he gave that speech, and then immediately it was about getting people to proceed over to the Capitol and storm the Capitol.
Right.
Yeah. So it was all about trying to produce that effect. And was it likely to produce that effect? We have the proof is there, right? It was likely. And so you can argue that, in fact, it was incitement under the constitutional test. So no free speech protection. Okay. And then the other argument is, even if it doesn't necessarily technically meet that standard, that's not necessary for purposes of impeachment. The Brandenburg case and test applied only in the criminal context.
Right.
Not in the impeachment context. This is only about disqualification. That's it. And so the Supreme Court has never ruled on what incitement means in the context of impeachment. So you can argue the Brandenburg test doesn't matter. Whether it was met or not met, it's not relevant. Okay, it's up to Congress to figure out, was this incitement for purposes of impeachment as a high crime, right? It showed, this action show that it shows that he's unfit for office. And the other argument is to say, bring up the first impeachment, right? Remember the impeachment for bribing and extorting Ukraine. If you accept their argument, oh, free speech allows him to do whatever, that would allow, his argument would support arguing that bribery is protected by the First Amendment, which obviously is not true, right? What was the basis for his bribery charge in the first impeachment? That's that phone call, speech, do me a favor, right? So throw that at people and say, no, you can't bribe people. Free speech is not a protection for bribery or extortion.
No, it's literally in the Constitution.
The Constitution, absolutely, right? Bribery is a basis for impeachment. Yeah, exactly. Free speech does not protect in high crimes and misdemeanors. Okay, and then so that's the argument with respect to whether or not he did or didn't incite based on that speech. The other argument they made was, well, it wasn't incitement because the storming of the Capitol was pre-planned. That all these people, it was them doing it on their own, and Trump had no role in inciting or getting people to storm the Capitol. Okay, so I think a couple responses to that argument. One, don't focus just on January 6th. It's not just the speech on January 6th. If people say, well, his speech didn't incite, no. If you look at the arguments made by the House managers, was his tweets, his conduct, his speeches leading up to January 6th was also part of the incitement.
That's why all the people were there.
Right, exactly. It was all about it. And I actually, and this is my personal critique actually of the House managers, that I think they should have gone beyond just incitement and argue that it was Trump helping to direct, plan, and help organize the storming of the Capitol. And even though that's not what technically the articles of impeachment is about incitement, there's no harm in arguing that that's what he did as well. So it's not just speech, it's not just incitement. No, he helped organize the thing, right? It was, he was the mastermind. And so go beyond just the January 6th speech, and then focus on some very incriminating tweets before in December that not only was he aware of what was going on, the planning, he was helping it out, and he was encouraging it. It wasn't just January 6th, it was leading up to January 6th. Okay. And then the other argument is that, well, even if it was pre-planned, there were some people there who weren't part of the plan. And so it did incite some people who weren't originally going to have planned to storm the Capitol to in fact storm the Capitol. So the fact that some people had pre-planned and organized it beforehand doesn't mean he also didn't incite other people there spontaneously to storm the Capitol. Okay. So I think those are some talking points to address the free speech argument. And I think that's it. It's jurisdiction and free speech, and there's no other defense. So if you can really undermine those arguments, I think you're going to leave them kind of speechless as to how to go about defending him. Okay, so yeah, that's all I have for in terms of today's presentation.
Really, really, really helpful. Great framing. I hadn't quite heard about it heard anybody talk about it in quite that way. So I really appreciate that. I'll try and I'll probably rewatch this video and see if I can sort of distill that a little bit to some social media nuggets that we can send out. Does anybody? So Trudy, I think that Reggie did address your sort of comment / question about, you know, that it's about setting a precedent for presidential conduct in the future. And then the other question that rolled in was around whether we'd make this video available, and I will. I'll post it to YouTube as soon as we're done, and I'll include it in the email out. So, anybody else have any questions for Reggie? Okay.
Why are senators allowed to work with Trump's defense team? Because with the impeachment trial, they can do essentially, aside from the procedures laid out, what they want, right? We talk about them as jurors, but they're really not jurors. Okay, it's a political process, not a judicial process. Okay, and unfortunately, it's not about it. We all know, right? People have their partisan views, and in reality, acting in a biased manner, right? There are no rules about that in the impeachment trial. Okay, so there's nothing that says, well, if you do that, then you can't be a juror. Okay, so even though we think about it in terms, even though it's really unfair, it does seem unfair. It does seem not a really fair process. If you understand as a political process, they can virtually do what they want. Unfortunately, that's the answer. Yeah.
Let's see, and then so Mal's question here, moving fast. Why? Oh, that's Joanne. Sorry, my scroll button isn't working very well here. What's better messaging for the left, as opposed to talking about the? Mal, I don't know. I'm not sure what you're asking.
Yeah. I think one response, if you're talking about, you know, the critique about, well, why is Cruz talking to the defense team? I think we should just drop it. Like, don't focus on it.
Yeah. It's kind of a side and apart from the key thing, which is really just his guilt, you know. And we're not going to sort of. I guess I'd say, for right now, that isn't a talking point.
Yeah.
As soon as he votes to acquit, then we can pile on all we want.
Yeah.
And then why aren't they going to subpoena Trump and call witnesses?
Well, they will have that debate tomorrow, and you know, they can theoretically subpoena witnesses. I highly doubt that will occur. Okay, why won't they subpoena Trump? Like I said, they theoretically could do so, but that raises a whole host of legal issues, because what is he going to do if he gets a subpoena? He's going to not respect it. He won't honor it. And then the question, how do you enforce it? Well, that's the problem, right? How do you enforce a subpoena if he doesn't relent? And there's some civil and criminal contempt process. You got to go to court, except, you know, then they're just too complicated. The process is very complicated, and you may never get him to actually. So the likelihood, even if you subpoena Trump, the likelihood of that subpoena actually working, highly unlikely. So, and the House managers know this, so that's why I think they're not going to go there, even though it makes absolute sense for them to do that.
And Beth asks, don't elected officials have fewer free speech rights than private citizens? The defense claimed otherwise.
Yeah, well, he actually tried to argue, defense tried to claim they have more free speech than private citizens, and that actually isn't true. I think he was trying to argue, well, when you have political debate, like in Congress about debating over a bill, There are some protections in terms of being a legislature, legislating, then you can't be sued on that basis for what you say in your official capacity. That may be what he was talking about. I'm not sure, but it's just not true that they have more protections, free speech protections, than say an ordinary citizens. And in fact, there's a doctrine where if you're they're essentially government employees, right? If you're a member of Congress, and there are rules saying you can restrict speech of government employees based on the government, and they have lesser free speech protection. So I don't know what they were talking about.
Claire McCaskill says that the senators who might be moved are most concerned about how Trump continued to attack Pence in Twitter, even after he knew he was in danger. They could be swayed by this very personal story. Agreed. I think that is one of the most compelling things to be sharing, is the thing about Pence, and this new one that just came out about his conversation with Kevin McCarthy on the phone, where he basically gave him the finger and said good luck. So yeah, definitely highlight that piece of the story as much as possible. Rena asks, can this incitement and events of January 6th be pursued in a regular court where jurors would have to act with impartiality just for curiosity's sake, not for messaging?
Yeah, absolutely, right.
Yeah.
Incitement is a criminal offense, incitement to violence. So yeah, he could potentially be indicted and subject to a criminal trial, and then yes, you'd have impartial jurors. Mm-hmm.
And potentially civil too, right? I mean,
yes. Mm-hmm.
Officer Sicknick's family
right.
could yep. decide, hey, wait a second.
right.
If this is a political process and not judicial, how would a subpoena be enforceable?
Congressional subpoena, not a judicial subpoena. Right. So Congress has the power to issue subpoenas, and that's why it's a trickier process than a judicial subpoena, because they can't enforce their own subpoena. They have to go to court to do so. So there's all these steps involved in enforcing a congressional subpoena. Mm-hmm. Unfortunately, that makes it much harder and unrealistic.
Right. And then I think the last question we have here is, can they have a secret ballot?
Fortunately, the answer is no, according to Senate procedures, right? The Senate procedure rules. And there's nothing in the Constitution that says it has to be a secret ballot or there can't be a secret vote. But there are procedures that say voting has to be public. And so, unfortunately, we can't. I guess they could technically always vote to say, well, let's have a secret ballot, but you'd have to have a vote. And I don't think I'm not sure the process for what the process might be for that. And I'm not sure they'd have the votes for that.
Yeah, and I think the other thing is, if it's sort of a calculation, if the Democrats think that they don't really have the votes anyway, then we want to get them on record.
Mm-hmm. Right.
We want to know how they're voting. So you're kind of taking a leap of faith, assuming that a anonymous vote would end up with a conviction. So. It's not a super clear-cut decision for either side, I don't think, about how to handle that, but it's highly unlikely given the current rules. So,
mm-hmm. Well, Pete has a point about the standard for presidential conduct feels relevant for social media posts. I think so, right? I think you should hammer that point that this is what it's about, and that's mm-hmm. what. Focusing on saying you got to have a conviction or acquittal on the merits, on his conduct, right? And not this whole, no jurisdiction.
Right. All right. I think that's it. We try and keep these to 20 or 30 minutes max. Mm-hmm. We're at 35. Obviously, it's been awesome and super fascinating to hear your take on this, and I'm going to go and play with some of what you said and try and convert it into amplifiable language for our toolkits.
Yeah, I'll send you my notes so you can.
That'd be great.
That. Yeah,
that'd be great. Thank you, and thank you everybody for joining and for your continued work. And we'll see what happens tomorrow, and we'll flip the switch and we'll start going after the GOP senators if it comes to that, if they actually do a vote. So. All right. Thanks, everybody.
All right. Thanks.
Thanks, Reggie. Bye. Bye.
You're welcome.